please remember to leave a like, a comment, share the video about, and if you haven't already, subscribe. Thank you. Well, isn't this just fantastic?
With that, as stated, I will not be talking about my case. I will be resuming content focused on the same things we always focus on. That content will be absent any alcohol or anything else. That content will be jovial and lighthearted most of the time. Except maybe if I'm in a bad mood. Because guess what, guys? You've always gotten me. Not a performative thing, not some mask, not some persona. You get me.
On this channel I've done a few shorts talking about the arrest of Nick Rekieta, the law YouTuber guy, and some of the concerns raised by many in the online space when it concerns certain narcotics like sherbet being in the home where his children also reside. Recently Nick made a triumphant return to YouTube, and he made a few comments of interest towards the government, towards legal officials who he named where he should not have named them. Around this time, a document was released into the online space, and Nick Rekieta has basically confirmed the existence of this document. Whether or not it's truthful or not, it is a bit open to interpretation, because he doesn't outright state that it is truthful what it says within the document, only that the document exists, right? And I thought, first of all, I'll play that clip of Nick confirming this before we go through parts of that document that are relevant to other comments Nick has made.
We're just going to do this. I'm going to talk for a minute, very briefly, and then we'll, I'm going to read the chats, and then we'll go. This is not going to be a long stream. It was going to be a much longer stream, but first, the release of information that's supposed to be protected at a very specific time, right after I announce a show and right before the show starts, is something that is concerning. And of course, I will have a lawyer looking into that right away.
I have seen many within the YouTube space and Twitter space debating whether or not this means he is verifying that what is said in the document is truthful or not. If you're Nick Rekieta at the moment, it's not a good time. The response typically to those that are detractors has been to call you a bootlicker for the police and government shills, whilst simultaneously attacking the police and the government and legal officials.
Do not.
When his legal counsel, if they were smart, would be advising against it. What is held within the document that's been released is something you don't want to ever see, because if true, there's no coming back. And anyone that supports Nick Rekieta, if this is true, is a moron. Again, I say if, because it needs to be confirmed first. There are some that believe this is all too sus, and therefore it is not, cannot be, truthful in the slightest. I want it to be false, because I do not want sherbet and children to be anywhere near each other. Regardless of the context, the answer is always a negatory.
But I'll deal with it. Because unlike groveling, sniveling commentators online who've never had to deal with any actual adversity in their lives, that's what you do.
In Nick's stream, titled Time to Get Back to Work ... Let's Chat, which runs for 86 minutes 55 seconds, he spends a lot of time touting what could be regarded as a bit of a conspiracy theory that the government has it in for him. That is why this is all snowballing the way it is. Because conspiracy, and it comes across as such. So when he starts to push wider messages of how to handle government, I can fully understand those kind of messages in the context of what you're getting a considerable amount of blowback for. The like to dislike of the stream certainly lends credence to that, as does your own live chat from that stream telling you to hand yourself in because you're a criminal, and the comments underneath.
But right now, we have Constitution to worry about. My personal liberty is what I'm concerned with. The welfare and well-being of my family, despite the little memes about it, has always been and will always be my top priority. Anyone suggesting otherwise? Well, I don't want to violate YouTube's rules about encouraging self-harm.
There is not much in the way of public perception where you're going to look good, so you need to really dig deep in one particular area where you believe there's some validity. Whether there is any validity or not, we cannot say until the process has been completed. So yes, I do respect the system. Innocence until proven guilty, right?
Fight for your rights. You have them. They exist for a reason, including your right to free speech.
The document that has since been released is 11 pages long, 10 if you take out the end part that's not really relevant in the slightest. To page 1. The above entitled matter came before the undersigned Judge of District Court on June the 6th, 2024 at the Place County Courthouse, Wilmar, Minnesota. Present at the hearing were the following. List of people, including foster parents. All parties participants appeared in person at the beginning of the Joint Emergency Protective Care hearing and admit-deny hearing. The court met the requirement for hearing procedure outlined in law. Subject matter concerns the 5 children. Obviously for this video we don't need to see that part, referencing their names, date of births. Not relevant in the slightest for us anyway. Parentage: Kayla Rekieta, mother of the minor children, Nicholas, the father of the minor children. They are married, they share joint legal and physical custody of the children. Petition: a CHIPS petition was filed on the 24th of May 2024. The alleged statutory grounds listed in the CHIPS petition are incorporated herein by reference. The court previously found the petition establishes a, I don't know this word, do forgive me, prima facie, showing that a juvenile protection matter exists and the children are the subject of that matter. The court previously found the petition establishes a, that word again, showing that the children's health, safety or welfare would be immediately endangered if the children were released to the care of the parents. 7 is a little bit blurred, but I think I can make it out. Service: Mr. Rekieta, Ms. Rekieta were each personally served with the summons and petition on the 28th of May 2024. No motion to intervene were made. The ICWA, the protections of the Indian Child Welfare Act, do not apply to this case. The next part references McKenna's law, which also references children by name. Of course, we've removed that. Representation: the parents were previously advised of the right to be represented by the counsel on the record as required by Rule 36, and the parents were each represented by an attorney at this hearing. Ex parte hold and order of hearing: the children were placed on a law enforcement hold. The date of removal is the 23rd of May 2024. The facts that warranted the removal of the children from the caregiver on an ex parte emergency basis are as following. On the 23rd of May 2024, law enforcement officers from that Place County Sheriff's Office executed a search warrant at the family residence. During the search, narcotics and drug paraphernalia were located. The parents were placed under arrest and the law enforcement officers placed the children on a law enforcement hold. Continued EPC hearing. An emergency protective care hearing was scheduled to be held on May the 28th, 2024. Where's the why? At that time, the parents motioned to continue the hearing for good cause. The court found good cause to continue the EPC hearing to protect the rights of the parties. Testimony. The court received testimony from Ellishka, is that what that says? Sweep, Christy Barber, and Robert Rekieta. All witnesses were placed under oath prior to providing testimony. Exhibits. The court received the following exhibits. 1. Drug testing of the parents. 2. Drug testing of the children. That's interesting. Protective care determination. All parties and participants were offered the opportunity to cross-examine petitioner regarding the ex parte filings. After receiving additional facts, the court determined that protective care shall continue. The court makes the following explicit and individualized findings in support of continued placement. A. KCHHS received a report following Mr. Rekieta and Ms. Rekieta on May 23, 2024. The report was that law enforcement was going to the home of Mr. Rekieta and Ms. Rekieta to execute a search warrant. B. Upon executing the search warrant, the law enforcement officers found over 26 grams of sherbet, horse trank, other stuff, pew-pews, and ammu for the pew-pews in the house. C. Ms. Sweep, Ellishka I believe, if that's what it says up top there, went to the family home while the search was going on. At the time, she learned that the home was very cluttered. It was difficult to walk around the home without stepping on clothing, bedding, or blankets. The children were present at the home when Ms. Sweep arrived. One of them was not present. D. After being placed out of the house, the children were subject to hair follicle drug testing. All except one tested negative. 1 tested positive for sherbet at a level over 5,000 with a cutoff of 500. Mr. and Ms. Rekieta submitted to a hair follicle drug test through Minnesota Monitoring Inc. on the 30th of May 2024. The results of those tests have not been received yet. Mr. Rekieta and Ms. Rekieta revoked their releases of information from MMI to KCHHS. Because the ROIs have been revoked, KCHHS has been unable to monitor the parents through additional testing. F. Ms. Sweet went to the home on the 28th of May. She was allowed into the home but was not allowed access to the parents' bedroom. G. The GAL is in agreement that it is in the best interests of the children to remain out of home placement at this time. That point about one of the children via hair follicle testing having sherbet in their system over 5,000 with a cutoff of 500. This is the part where people really have latched on, and understandably so. I know that when I'd covered in like This Week at Twitter and in Shorts, some people on social media were like, oh yes, but the children aren't going up to it to use it, are they? So there's nothing wrong with the parents having it. Actually, there's everything wrong with the parents having this. My view has always remained the same when it comes to a parent having a child. The moment you have one, your life is over. Your life ends until that child leaves the home and they start their life. That's my view on it. Any parent reckless enough to leave firearms laying around, ammunition laying around, or drugs laying around, or paraphernalia for those drugs laying around, is a bad parent. Insert all your obligatory excuses here to try and simp to white knight to defend, but my point still stands. No one should be doing that. I'm intrigued by the revoking rights part, or access to further testing. That intrigues me. But we also have allegedly additional context from people going to the home and noting what a mess it was. You need to lead by example, Nick, and your wife, for your children. You, when you started up your stream again, spoke about how important your family was to you. Clearly that was not the case, allegedly, because you need some kind of shock to the system to learn the lesson. Any parent that requires that level of shock to their system to be better has already started off as a weak parent to begin with. Those children are going to remember this as well, by the way, and you should be ashamed of yourself for that.
Again, what's so shocking to me are all the lawyers who suddenly forgot that you can't talk about criminal case. They'll tell you, they'll say it. They'll say it on Twitter and stuff. They'll be like, oh, Nick shouldn't be talking. When I tell a joke about cops talking about my house, like, and labeled, this is clearly a joke. They're like, oh my God, Nick shouldn't say that. Ugh.
Nick, according to this paperwork, you refused to get a drug test, your wife included, to prove you were clean so you could in turn get your children back, or help get your children back. So it doesn't really matter what the jokes are coming from LawTube or other lawyers. Ultimately, they've busted you with one simple comment in an alleged official piece of paperwork. And your response is seen by many as a massive deflection from this, all under the convenient guise of, but I can't talk about this right now. You pretty much confirmed its existence. The truth of it is a different matter, but the existence part you did when you confirmed it was released, a document was released, just as you were firing up a stream, or just before if you want to be pedantic. Pointlessly, I might add. Now there is more in this document we should probably go through. 17. Surroundings or conditions. The children are in surroundings or conditions that endanger the children's health, safety or welfare, requiring responsibility for the children's care and custody to be immediately assumed by the KCHHS. 18. Contrary to welfare and best interests, children out of home. It is in the best interests of the children for care, custody and control of the children to remain with KCHHS for the purpose of placement with a suitable foster care provider. Continued custody of the children by the parents is contrary to the welfare of the children. The placement confirmed by the KCHHS is in the children's best interest. In making this finding, the court relies upon the best interest factors considered by the KCHHS as set forth in the CHIPS petition, which are incorporated herein by reference. It is in the best interests of the children to remain in foster care until the parents are able to provide a safe environment, demonstrated through substantial compliance with the case plan and by correcting the conditions which have led to out-of-home placement. The placement proposed by the agency is the least restrictive and most home-like setting that meets the needs of the children. 19. Reasonable efforts. Given the particular circumstances of the children and family at the time of children's removals, there were no services or efforts available that could have allowed the children to safely remain in the home. I'm just going to insert another obligatory, if any of this is true. You do realise how shitty this makes you look, right, Nick? I mean, you have to. You can call people bootlickers, government simps, you can go and deflect in that ballpark if you like. But if this is proven true, or any of it is true, this is horrific. You can't have your children because your home isn't safe for them, because of the narcotics, paraphernalia, and the random pew-pew crap you left laying around. Have you ever heard of a locker? And as far as the drugs go, they should never be in the house to begin with. You shouldn't be taking them. 20. KCHHS is providing reasonable efforts to reunify the children with their parents and to prevent the need for further out-of-home placement. However, those efforts have been hampered by the parents, because the parents have revoked ROIs, have not been submitting to drug testing, and have not allowed KCHHS full access to the home. This one baffles me a bit. I understand the individual rights and freedoms, but when it comes to your children, a good parent would do anything they can to get their children back. If you failed the drug testing, I understand there is a risk in that, which is more than likely what this comes across as, again, allegedly. However, you making consistent, concerted efforts to change and improve will help you, Nick and Ms. Rekieta. 21. Removal date and permanency deadlines. The children were removed from the home on the 23rd of May. The permanency progress review hearing must be held no later than 180 days after, which is November the 19th, 2024. If applicable, the permanency petition must be filed no later than 335 days after, which is April 23rd, 2025. An admit-deny hearing was held on the 6th of June, which is 22 by the way. The parents, each represented by an attorney. The parents were advised of the right to have a trial regarding the chipped petition, including the right to testify or question and call witnesses at the trial, and to require petitioner to prove its chips petition by clear and convincing evidence. The parents entered a denial. We're going to skip over this little part here, conclusions of law, and go down to order. 1. The children shall remain in the protective care for the purpose of placement with an appropriate licensed foster care provider. 2. Services, examinations, or evaluations. The following shall be provided to the child and the child's family pursuant to Rule 42-09. The parents shall each submit to a chemical use assessment and shall follow all recommendations. The parents shall abstain from the use and possession of all mood-altering substances except as prescribed by a medical professional. C. The parents shall each submit to chemical testing of any type at the request of the KCHHS and or the GAL to verify abstinence. This would explain why in his stream he has no intention of using it, which does lend credence to this being verified. D. The parents shall sign all necessary releases of information so that the service providers may share information with KCHHS and GAL. E. The parents shall sign releases of information from MMI to KCHHS and the GAL so that KCHHS and the GAL may monitor and verify the parents' drug testing results. At least before they get visitation, supervised, but they get some, right? I'm not trying to say that this is all but verified with these little parts here, but Nick's earlier comments about abstaining or not having anything around him that could in any way ruin the show, like alcohol.
As stated, I will not be talking about my case. I will be resuming content focused on the same things we always focus on. That content will be absent any alcohol or anything else.
This does seem to lend credence to this being verifiable now, but that's just an interpretation. Of course, I'm not going to state it as fact, just how it can be perceived. As far as I'm concerned, if this is true, you shouldn't have your children back ever. I don't care how many chances you think you should have. I hold very strict views when it comes to children and their welfare and their safety, and parents ultimately only get one chance. But I'm not a parent, so what do I know? Shoot me down, my opinion means nothing. Like I care. You are a terrible person, Nick, and you should be ashamed of yourself for getting into this hole.
Do not allow anyone to convince you that you should grovel before government or just accept an outcome. Don't do it.